business, legal environment, court system. Among various sources of law, we started talking about sources of law the very first day in class. But the source that's the supreme law of the land, in fact, there's actually a clause in the U.S. Constitution that says that it is the supreme law of the land. Federal judges and justices are nominated and appointed by whom? The President of the United States, and confirmed with the advice and consent of who? The Senate, not Congress as a whole. Now remember that one of the wrong answers is there's a different rule for treaties. There's a different percentage of senators that have to approve that. When we begin a civil or criminal case, we have a jury decide, where we're going to have the jury decide the verdict. We question the jurors. That process, the attorneys and sometimes the judges too, question the jurors to determine their fitness to be able to sit as a juror or whether they want them to sit as a juror. And that process is called a voir dire, V-O-I-R, D-I-R-E, and that is French for to speak the truth. At trial, there is a process where we examine and cross-examine witnesses. Normally, if your side, the plaintiff, let's say, puts up a witness, then you directly examine them, and then the defense will cross-examine. But when the defense puts up a witness, they'll directly examine their own witness, and then the plaintiff will cross-examine the witness. Appellate courts have three basic options, some combinations thereof, or modifications thereof, that they could do with lower court decisions. Appellate courts can affirm a lower court decision where they agree with it. They can reverse it where they don't agree with it. And sometimes when they reverse it, they also remand it for a new trial. I was involved in that armed robbery case that actually involved both a reversal for one guy. The court said you can't try him for nothing, he's off the hook completely. And a reversal and remand for my client. Okay. Jill Kirby, we know about her. She's got her lawsuit in the book. Her pleading, which was filed by her attorney against Antonio Carvello, I call him Anthony here, in federal court, her pleading was called the complaint, and in it she alleged the court's jurisdiction, the cause of action, because it was a negligence case involving a car wreck, and the relief or remedy which she was asking for. That's the complaint. Speaking of juries, there's two ways to challenge jurors. One is to challenge them for cause, where the judge has to determine that something's wrong, they've got some bias, they're sleeping with a witness or something, and they can't be a juror on the case. And the judge says, okay, take them off and get new jurors. But the other is called a peremptory. And although peremptory challenges, you don't have to give a reason, you're not allowed to discriminate based on race or gender, and you only have so many peremptory challenges. Attorney's fees come in various forms, including those hourly fees. I just heard that the average hourly fee is now $275. My hourly rate has gone up effective immediately to $275 per hour. The other types are fixed fees. You know, I'll do your LLC for $475. I'll do your closing for $600, something like that. But there's also a contingency fee, or a contingent fee, where the attorney gets paid part of what the plaintiff wins in the case. And that can include punitive damages, could be a lot of money. What's the burden of proof in a civil case? What's the burden of proof in a criminal case? Okay? United States Supreme Court justices and all federal judges are, according to the Constitution anyway, I didn't put in that in question, but we know that. Literally in the Constitution it says they serve during good behavior. We all say they serve for life. I even found that on the Supreme Court website. It says they serve for life, but the Constitution says they serve during good behavior. Chapter 4, Ethics, and 6 questions. All right, ethics is the study of what constitutes right and wrong behavior. Common ethical dilemma faced by management in a corporation usually involves the effect that decision-making makes to, the book says the stakeholders, but the stakeholders include the stockholders in the company, the owner shareholders, the Obviously, other people in the company, like employees, who may not own shares in that company, the community where the company is located, the vendors and suppliers that do business with that company, and certainly the customers and clients that buy from that company. Suppose that a company suggests to its employees they employ the categorical imperative. Be able to recognize that in print. It's a multiple choice question. You don't have to memorize as long as you know what it is. The next question, utilitarian perspective, same thing. Know how to recognize it. If the company says apply the utilitarian perspective, know what it is. Now there is a shortened version of that that is the greatest good for the greatest number, so that's a hint. We studied schools of ethical philosophy actually in chapter 1, but we talked about them with regard to chapter 4 in ethics and said that there's a lot of different schools: historical school, natural school, universal school, religious, Ten Commandments, stuff like that. But we also learned about this school where you had to follow the law no matter what. It didn't matter whether the law, it didn't have anything to do with natural or human rights, and the law could be good or bad, that was irrelevant. That was called the positivist school. Questions of corporate social responsibility involve the extent which a corporation has ethical duties beyond those mandated by law. A lot of the ways that corporations get in trouble is they don't do stuff illegally, but they act unethically, and we all hear about it and don't want to do business with it. And remember, law is only an ethical minimum. Constitutional law, chapter 5, and criminal law, mostly constitutional stuff, from chapter 7. 7 questions. The constitutional right of privacy, you will remember, is judicially derived or implied from the constitutional amendments. It's not specifically stated anywhere in there. There is no right to privacy except that which has been derived by the Supreme Court of the United States. The written document by the Constitutional Convention of 1787 became known as the U.S. Constitution. The Bill of Rights refers to the first 10 amendments to the United States Constitution. Those are two of the easiest questions on the exam. You'll remember the case involving Ollie's Barbecue and old Katzenbach versus McClung. McClung was the owner. He had this place in Birmingham, Alabama, and he claimed the Civil Rights Act didn't apply to him, and the court said that it did because he was engaged in interstate commerce. He said that he was not. Now, there are two answers on this test question that are identical except for 2 letters. One says interstate, and the other says intrastate. Again, generally the court is looking for interstate activity, and therefore interstate commerce kicks in. Freedom of speech is not absolute. It doesn't protect things like pornography or obscenity. But again, defining that is very difficult. Well, it's clear, though, that it doesn't protect defamation. In other words, if you're defaming someone, you can't say, well, I was just exercising my freedom of speech if you're telling lies about someone. One of the exceptions to the requirement that the government go get a warrant is called the plain view doctrine. This works in automobiles, but it also works in homes. If the police can look into a house or a car and see something illegal, then they can probably go in without a warrant. In a car, it's typically something like a marijuana cigarette roach in the ashtray, the butt of a gun or a knife, which is a concealed weapon, or an empty alcohol container. The exclusionary rule is the rule that says that if the government seizes something illegally, it's not allowed to use that. It's excluded from trial. They can't introduce it into evidence or use any fruit of the poisonous tree. Chapters 9 and 10, contract formation and performance, 36 questions, a bunch of questions here. Again, with chapter 16, which is 15 questions, a total of 51 or 50% of your exam. Contract, not the one in the book. Contract consists of a legal agreement between 2 or more competent parties where consideration is exchanged now or in the future. Next question. We studied some terminology like bilateral and unilateral, which I'll get to in a minute. But we also studied executed and executory contracts. An executed contract is one that's been fully performed by both sides. The example in the book is the coal company delivers coal to Jackson, which is a steel mill. The coal company has done what they needed to do. They ordered the coal bed order, they delivered it, they left it there, they left an invoice to be paid. Jackson had not paid yet, so Jackson's part of the contract is still executory. You will get a fact scenario exactly like that, but it's not Jackson, it's not the coal company, but the outcome is the same. In order to have an offer, you have to have three things. The offeror must objectively intend to make an offer and be bound by it. Terms of the offer must be reasonably certain and definite. Let's just go with definite. The offer must be communicated to the offeree. You remember I wrote a question on the board one day. It said contracts may be in writing, implied, verbal, expressed, and the answer is any of the above. Even combinations. They can be expressed in writing or expressed verbal. Suppose your uncle says he'll give you $500 for Christmas and then he doesn't. Can you sue him for that? No. Because you haven't given him anything in return. You haven't given him any consideration. It's a gratuitous promise. It's not binding. Bilateral contract is a promise for a promise, usually to be performed in the future. Unilateral, though, is a promise, which is the offer, for an act, and the act is the acceptance. In other words, on a reward, you can't just say, I agree to your reward offer, and then go out and try to perform it. You have to actually perform it and find the missing dog or turn in the criminal for the reward. An oral contract for sale of an interest in real property is unenforceable, and that's the word we're supposed to use, but again we use that word pretty loosely. The other thing is the North Carolina statute on the statute of frauds for real estate actually uses the word void. So I'm going to say unenforceable or void under the statute of frauds. Can't have an oral contract for sale of an interest in real estate. Next question involves something like you and me in your car. And let's say that we're discussing me buying your car, and you say, hey, I like your car, would you consider selling it? And you say, actually, I've been thinking about that, but if I said, well, if you were going to sell it, what would you want for it? And you said, if I was going to sell it, this is what I want for it. That's like preliminary negotiations or statements of future intent. That's not an offer. It's not really an acceptance. There is no contract. In Lucy versus Zimmer, the case was all about contractual intent. Yes, it involved alcohol and being high as a Georgia pine, but it was not about intoxication as a legal defense. It was about intent. Charging of illegal interest on a loan of money is usury. Remember, I promised you I would come up with other U words as the other wrong answers. So I've got uttering and some other U words in there as the wrong answers. But usury is the answer. We've studied different ways to automatically terminate an offer prior to acceptance. There were 7, and 3 of those involved acts of the parties: withdrawal or revocation by the offeror, the one who made the offer, a rejection by the offeree, a counter by the offeree, where the offeree becomes the new offeror, and then we studied 4 different ones that involved operation of law: lapse of time, destruction of the subject matter, death or incompetence of the offeror or the offeree, and its supervening illegality. Next question involves a minor, where, remember the rule with a minor is when they enter into a contract, they can avoid it after they become an adult. They do it while they're still a minor. They have to do it through a guardian or someone. All right, but they have to do it within a reasonable time in most states. No statute of limitations per se, just whatever is reasonable under the circumstances. So the judge or jury will determine that. So I'm going to give you an example of a minor who decides on his birthday or the day after he turns 18 to change his mind and back out of the deal. So that's reasonable. Believe me, the day you turn that age or the day after is certainly a reasonable amount of time. Okay? Contract between a U.S. citizen and a non-resident alien. May or may not have talked about this in all the sections. don't remember, actually. It's not in the book. You can make a contract with an alien, and generally it's considered to be a valid contract, whether they're illegally in the country or not, and whether they're a non-resident or not. The only time you're not allowed to enter into a contract with somebody or a company from another country is when we're at war with that country. The equitable remedy for misrepresentation or fraud is rescission. Normally you rescind a contract if you've been defrauded, and usually there's restitution too, where if you sold me a car and you lied about it, I give you the car back and get my money back. There are certain situations where we have an executed contract and you can't say that the contract's no good. But if you said it was no good before it was fully executed, you could undo the contract. What about some of these situations where you can do it even though it's fully executed? Well, in usury, you can do it after it's fully executed. In fact, you can borrow money, know it's usurious, know you're paying too much interest, go ahead and borrow it, pay it back along with the interest, and then you still have like a year statute of limitations or something to sue on that and get some of your interest back, and possibly get your attorney's fees. But that doesn't work that way with an unlicensed contractor. Remember, an unlicensed contractor, if they entered into a contract with you to build a house, say over the unlicensed limit is $30,000, so say build it for $35,000, you have the right as the owner not to pay them for that. Assuming they've done all the work and they've been paid some of it, you don't have to make the last payment if you don't want to. But if you do pay them, you can't sue to undo it. Same way if you lose money in a poker game, or if you make a unilateral mistake of something. A counter offer is what? It's an actual rejection of the original offer plus a new offer. Okay? So they switch hats. A reward has different characteristics about it. A reward for, say, return of a lost dog, or turning in a criminal or something like that. If it's printed in the newspaper, that is an offer. Or if it's on a poster on the wall, that is an offer. Unlike most offers, you advertise the sale of your car, that's not an offer. All right? But a reward is also an example of a unilateral contract where if somebody does find the dog and accepts, therefore performs the act and accepts the offer for the reward, then it becomes a unilateral contract. We studied examples of pre-existing legal duty in the book, and I've got an exam question here. This is straight out of the book. Remember the two types mentioned in the book. One was the sheriff has a legal duty to arrest the fugitive, and the other is the building contractor who says they need more money on a fixed price contract. You don't have to pay them because they've already agreed to perform the contract on a turnkey or fixed price deal. Among the various types of damages we studied, we had punitive, liquidated, nominal, and the two main ones, which were compensatory, which are direct damages, and consequential, which are special or indirect. Suppose a person is adjudicated incompetent by a court, and normally they would be institutionalized. Well, let's just assume that that person's incompetent and they're not in the institution and they escape or whatever, and they go hold a big yard sale and they sell a bunch of stuff. All of those contracts are void. V-O-I-D, unavoidable but void. All right, next question involves you and me in the car again. And this time we say, okay, I'm going to switch tables and say you're buying a car from me instead of me buying from you. Let's say you made me an offer to buy my car, and you said this offer would, I have to accept or reject this offer on or before 5 p.m. on Friday, otherwise the offer ceases to exist. We'll say next Friday, okay? But before next Friday gets here, or maybe that morning before 5 p.m., you come to me and say, I'm withdrawing my offer. And I say, no, you can't do that. You gave me till 5 o'clock. The answer is you have the right to withdraw that offer at any time prior to being accepted, whether or not you put a time limit on your offer in the offer that you make. You have a right to withdraw. If you're thinking about breaching your lease and skipping town at the end of final exams here, and you got a lease that runs through August, your landlord's still required to try to mitigate their damage. Mitigate means lessen. Unconscionable contracts. We saw that in the book. I didn't give you a lot of examples of it, but you need to know what the rule is and be able to recognize the term. It's a mouthful. Contracts that are unconscionable are ones that are fundamentally or grossly unfair or oppressive to one of the parties to the contract. So again, difference between what I paid you for your car and what it was actually worth might show up as an unconscionable contract. But normally that's not the issue for the courts. In order to prove undue influence, we have to prove the existence of some sort of a confidential relationship between the parties. Usually it's the party who is unduly influenced by someone who had a confidential relationship with them. So it could be like an attorney and their client. If I, kind of made a client do something, usually it would benefit me directly, that they wouldn't have normally done. I influenced them unduly. That's a confidential relationship. Or some elderly person in your family and your greedy uncle. Suppose that the owner and the builder are contemplating a contract to do some improvements on the owner's house. The owner wants the builder to be finished by a certain date and wants to put in some kind of a clause that says the builder will owe so many dollars per day if they're late. That kind of thing is usually difficult to estimate what the true damages are. So the parties are allowed to put in the contract that a reasonable amount, not a penalty, not excessive, that based on the circumstances and based on the difficulty of coming up with a dollar amount. That's called liquidated damages. It's one of the last things we studied. All right. We talked about that consideration can include an amount equal to money, valuable car, or something like that. But it can also consist of refraining from doing something, like Hamer versus Sidwell. The example I used in some of the sections, and maybe not in this one, but it is where somebody's painting a house, and the neighbor doesn't like it. Let's say I'm painting my house some ridiculous color, and the neighbor doesn't approve for it. So the neighbor sees it, comes over and says, oh, would you please paint your house something else? And I say, well, I like this color. I have a right to paint this house this color. The neighbor says, I tell you what, if you will go with me to the paint store, we'll pick out a paint we both like, and I'll pay for the paint. So the neighbor's given up money for the paint. That's their consideration. What have I given up? I've given up my right to paint it whatever color I want. So that's my concern. And that makes the neighbor feel better too, so they do receive something. Foreseeability. I talked about this and I told you there might be an exam question. I actually modified this question because I went in the book and I looked and I said, in the index, how many times is foreseeability mentioned? It was mentioned 3 times. The problem was they left out some of the obvious statements of foreseeability. One of those was Hadley versus Baxendale. I know that case is not in the book anymore. But the reason they didn't catch it was it's in there under not foreseeability, but whether the thing was foreseeable. So they didn't catch that word. So, foreseeability, where do we see it? We see it in negligence under proximate causation. Was it foreseeable that that guy was carrying fireworks when Helen Ballsgraf was injured? We see it in contracts under pre-existing duty rule. If the builder is able to say, well, that was an unforeseen circumstance, a judge might let him off the hook. That was mentioned in the index, by the way. It's also a factor in Hadley versus Baxendale or consequential damage, and several other places, by the way. Courts look at covenants not to compete very strictly. They don't like them because they impair free enterprise and free competition. But courts will uphold a covenant not to compete, especially in an employment situation, as long as it's very reasonable in time, reasonable in geographical scope, and it can't be any greater of a restriction than is necessary to protect some kind of a business interest. So, meaning that it can't be too vague or broad. It has to be very narrowly defined. when you're trained to do a job at an employer and later you quit, you can't just forget your training. But they can restrict you competing with, you know, a competitor, going to work for a competitor or opening your own business within a geographical area that's small, over a small amount of time, and they need to specify what it is you can and can't do, very detailed. All right, when a person who is a party to a personal service contract where that person has to perform, Fred in the valet, the attorney you hired to do your estate planning, dies or becomes incompetent, then you can get out of the contract. The contract is discharged. This is a type of impossibility of performance, just like destruction of the subject matter. No contract exists under mistakes. Remember, the rule is very simple. Explaining it is very difficult. The cases go both ways. I sent you a memo on this, but believe me, I'd love to have more questions on mistake of fact, but the general rule is the only time there's no contract is when there's a mutual mistake of a material fact. All right? Speaking of talking about mistake cases, when we were discussing voluntary consent or genuineness of assent, we said that it's a defense to a contract's validity only in certain cases, such as undue influence, mistake, duress, and that it also has to do with the meeting of the minds. Think of the peerless case. Remember, the problem is they both had a peerless in mind, and they didn't know they were talking about two different peerlesses. There were two different ships. It was a mistake anybody could make. But one was thinking it was this peerless, the other was thinking that. They were mutually mistaken. There was no meeting of the minds. They hadn't agreed on the same ship. Maybe if they'd agreed on the shipment date, they could have gotten that figured out, but they didn't do it. So, meeting of the minds. There's a tort involving contract law that's also a crime. That's fraud. Contracts can be discharged in a number of ways. We discussed a bunch of them, including things like lapse of time and destruction of subject matter. Well, destruction of subject matter was under impossibility, but we also studied bankruptcy, frustration of purpose, the English coronation cases, and expiration of a statute of limitations. Suppose you received a credit card offer in the mail that you did not request. In other words, you have no pre-existing arrangement with this credit card company. And in the thing it says, here's your credit card. You will be billed an annual fee at the end of your first year, whether or not you use the card. Silence in replying to this letter is considered an acceptance. That is not an acceptance. Your silence cannot result in acceptance of the card or the annual fee. Now, if you use the card, that might be enough. Termination of an offer sometimes happens when there's also termination of a contract. Examples of that I gave you. One of those that was the most obvious, though, was the subject matter is destroyed. If I make you an offer to buy your car and you wreck it, that's the end of the offer. If I make an offer to buy your car and you agree to it, we have a contract but we haven't completed it yet, and you wreck your car, we still don't have a contract. The mailbox rule, remember, is a very specialized rule on communication of acceptance. It also has another name. It's referred to as the deposited acceptance rule. And actually, that's a good way to remember what it really involves. If someone sent an offer in the mail and they deposit it, they sign it, agree to it, and send it back in the mail, when they put it in the box, then it's deemed to have been communicated. Towards chapter 12, we didn't really do any chapter 13, so it's just chapter 12, 9 questions. When Ford used the voice of someone who sounded like Bette Midler in their commercial without Bette's permission, that was the tort of appropriation. Next question, one you've seen before. I think you've seen the Bette Midler one before too. This is also a repeat, but this is the one that practically everybody, like 70-something% of the class got it wrong. 70-something% of the class answered A, which can never be the answer. The guy drives his car negligently in the telephone pole, it knocks out the power, it knocks out the hospital generator, and the guy dies. All right. You can argue that that's not actual cause, but that's not one of the answers. One of the possible answers is actual cause first, which you have to define. Then you can look at proximate. But here that's not really proximate. It's a judgment call, I know, but that's what basically is going on. Don't say, and this is the wrong answer, that it's proximate cause, but not actual. You've got to look at actual first, and if there's no actual, you don't even consider proximate. Next question, similar to one on your last test. Like, somebody wakes up, there's an intruder in their house, and they shoot him. Okay. So it's similar like that, but it's a little different, because this is the Durham case, where the guy actually caught some people trying to steal from him, and then ran them off and shot them in the back as they ran away. You can't do that. That is some kind of manslaughter or murder. He was actually tried, the jury let him go, but that's just one of those jury things. They can let him go if they want to. Turned out they did, but he was still prosecuted and went through a lot of agony to try to get out of that one. To completely prove negligence and recover damages, we had an outline. The outline was there has to be a standard or duty of care, there has to be a breach of that duty, there has to be actual and proximate cause, both, remember actual first, then proximate, and there has to be some injury or loss or damage that was caused by that breach of the duty. Paul's Craft case, she lost. Court said no proximate cause. It was really a more involved case than that, but that's what the court said. The famous case involving intentional interference with contractual relation in your book, it's a footnote, is the famous Old English case of Lumley versus Guy. This is one of the few questions where you have to remember which case involves which tort. Lumley versus Guy. I'll give you the other wrong answers. Raffles v. Wickleshouse. That was the case involving mutual mistake. Hadley versus Baxendale. That involved consequential damages. Lucy versus Simmer involved contractual intent to make an offer and have a contract. Hamer versus Sidway was the refraining, the forbearance case. All right, in defamation, in order to prove you've been defamed, you have to normally prove a false statement has been made about you that damaged your reputation. But if you're a famous person, you are also required to prove one other thing. And that is that the statement made against you was made with actual malice. It's not that somebody made a false statement, they knew it was false and they made it anyway. Assault. Assault and battery are different. Remember, assault is putting someone in fear or apprehension of immediate harmful or offensive contact. Not future contact, not past contact. And now you can put here not past, present, or future, or offensive. Meaning it's got to be immediate. It's got to be right now. Contributory negligence is a defense in tort cases, but so is comparative negligence. Some states use contrib, others use comparative. North Carolina is one of 4 states, I think, that still uses contributory. In North Carolina, if Stella Liebeck went and spilled her hot coffee on herself, and the jury determined that she was partially negligent, matter which way, that if the jury determines that she was partially negligent in a comparative negligence state, which is what happened, they reduced her award by 20%. If a jury in North Carolina determined that, she'd get nothing. 0. It's a complete and absolute defense. Chapter 16, chapters 9 and 10, which are 36, this one's 15. Total of 51 questions. Chapter 16, mortgages and foreclosures after the Great Recession. A borrower or debtor in a mortgage or deed of trust is called the mortgagor. The mortgagor. We say that the lender is the mortgagee. We sometimes use those terms even when we're talking about deeds of trust. In a purchase situation, the difference between the purchase price and your new loan is what you're putting in. That's your down payment. We'll talk about later that also could be your equity. When you purchase something, at that moment in time, that's your equity as well. Your down payment's your equity. But later on, your equity can be something different, and we'll talk about how to define that. A sale of real property for less than what the seller owes on his or her mortgages is a short sale. The acronym ARM, what does that stand for? Adjustable rate mortgage. The real estate you pledge for a mortgage or deed of trust is the collateral. When you make a fully amortized loan payment, on a fixed rate loan especially, your loan payment's the same every month. Part of that is principal and part of it's interest. And the amount that's principal and the amount that's interest changes every month. Because you start to pay your principal down and there's more principal paid on the next payment, less interest, till you get to like your last payment and it's almost all principal and just a little bit of interest. The prepayment penalty is a penalty or fee charged when you're making early payment of principal. Most residential loans don't allow prepayment penalties, but that's what it is. The postponement for a limited time or all or part of your payments on a loan with agreement by the lender is a forbearance. Now remember, we studied other types of forbearances as well. We said that in Hamer versus Sidway that was a forbearance when he didn't cuss or drink or whatever for 5 years. When your lender forecloses on your property, if you still owe money after that, in other words, whatever's bid on the property is not enough to pay off the loan, even if the lender's the high bidder, then they can sue you again for what's called a deficiency. They sue you directly now, personally, to get a deficiency judgment against you and try to find other assets that you've got to collect on. There's different types of rights of redemption in a foreclosure action. One of those is statutory, meaning that you get a right of redemption by law. The other is equitable, and that means kind of by common law. And that works this way in North Carolina. You have a statutory, an equitable right of redemption up until the day of the sale, and then after that you have a statutory redemption period during the upset period. In some states, though, the statutory right is like a year long, and so that's you still bail yourself out. Two types of foreclosure: judicial sale and power of sale. Difference between what is owed on a real estate, your loan balance, and the market value is your equity. Now, at closing, yeah, that's whatever your down payment was. But later on, you've paid more on it. You paid off your loan to some degree, so you owe less. And the value of the property might have gone up or down. So the equity at any moment in time after that is going to depend on what the current market value is and what your loan balance is. Okay. Borrower is required to purchase additional insurance when they borrow money over 80% loan to value. That's called private mortgage insurance, PMI. A subprime mortgage is what? Well, I'm going to use the definition out of the book, even though there's one word I'm a little unsure of. It says a loan made to a borrower who does not qualify for a standard mortgage due to poor credit score and or a high debt-to-income ratio. Now remember, the standard, I don't know what they mean by standard mortgage here, but again, normal mortgages, you're supposed to have no more than a 28% debt-to-income ratio. So maybe it includes that kind of thing, and that's what they mean by standard mortgage. A mortgage that's recorded first at the courthouse has priority to a mortgage that's recorded later. But sometimes you'll get a first mortgage and then you'll get an equity line on your property. And you may or may not owe anything on your equity. But when you get to refinance your first, if you want to keep your equity, we have to do something to say that equity line is not in first position with regard to a new line. So we will do a subordination agreement. We will subordinate the equity line to the new first mortgage. The lenders have to agree to that. The holder of the equity line has to agree to that. Chapter 17, 18, and 19, 13 questions. That's all those business entities that we did. 13 questions, and then we'll have 5 questions in agency. All right, 13 questions first. Remember this question on a previous test. Most of you got it wrong. When a partnership owns real estate, your interest in a partnership in North Carolina, because the partnership is considered to be an entity, your ownership interest is a personal property interest. It's the same thing if you own stock in General Motors and you do not own the real estate that General Motors owns. You own stock. That's an intangible personal property right. It works the same in partnerships because partnerships are considered to be entities under UPA and RUPA. Business organizations that were required to file some articles or certificate with the central state agency. Now remember, under the latest revision of RUPA, it is possible that partnerships can file something, but it's not a requirement in order to create the document. The only ones that we have then in North Carolina, because we don't have the latest version of RUPA, is limited partnerships, corporations, and limited liability companies. That's a repeat of an old question on an old test. Another repeat is, what's the internal document for an LLC? That's the operating agreement. That's not the one you file with the Secretary of State. I've got a client right now, when I leave here, I'm going to go back to my office and work on an operating agreement for a guy. Why? He's already done his LLCs. He's done 2. He filed them himself. I didn't help him. But he doesn't have an operating agreement, so he needs one, and I'm going to help him with that and charge him. A limited liability company is owned by whom? Remember, owners can be members, they can be shareholders, they can be partners, they can be limited partners in different kinds of business entities. Which one of those is for LLCs? Also remember which type of corporation is subject to double taxation, C or S. And in a general partnership where all partners are natural persons, meaning they're flesh and blood, you and me, they all have unlimited personal liability. In a general partnership, everybody has unlimited personal liability if they're natural people. Now, you could have a corporation that owns a partnership interest, and then there'd be some other rules. In North Carolina, you can have a corporation, LLC, or by definition, a sole proprietorship that only has one owner. My LLC happens to be a single owner LLC. There's a document filed when your business does business other than its own name. So if I do Rick's Law Clinic, then I need to file an assumed name certificate for that in the county where I do business. Normally, day-to-day operations of a franchise is left up to the franchisee. Now remember, the franchisors have a lot of controls over what the franchisee does, and I emphasize some of their rules and details and all that and requirements that they have. But they better be careful if they try to run day-to-day operations. Why? Because if a franchisor tries to run the business for the franchisee, then they become liable for torts committed by employees of the franchisee in the business. A corporation that is incorporated in one state, does business in a second state, is referred to in the second state as a foreign corporation. The person who signs and files the articles of organization with the Secretary of State now includes an organizer or a member. When I did mine, it was just organizers. Now you can have a member. Small, closely held corporations, general partnerships, limited partnerships, all those little entities that are closely held. We've got more than one owner. I always recommend that they have a buy-sell agreement where transferability of ownership is limited. No partner can go out and sell their interest on the street or on Craigslist. No partner can die and then their heirs become the new partner. They have to offer the ownership interest to the other members who are surviving or remaining. It's like the right of first refusal. A nonprofit corporation, not all nonprofits are tax exempt. Remember, to be tax exempt, you have to first be nonprofit. But it's not the other way around. If you're tax exempt, you're obviously nonprofit, but not all nonprofits are tax exempt. A good example of that is a homeowners association that collects dues. Agency, 5 questions, and then we'll be done. An agent for an undisclosed principal, remember, is personally liable in contracts, also for a partially disclosed principal. And of course they're liable in torts just like they always were. The principal is also liable in those cases. Under the doctrine of respondeat superior, we have something called vicarious liability. The employer is the principal and is vicariously liable for torts committed by the employee during or within the scope of employment. That's not generally true when you're dealing with an independent contractor. The employer, again, not with an employee now, but with an independent who contracts, or the owner who contracts with the independent contractor commits a tort in the performance of the contract. The employer is not liable. We had 5 duties that were owed by an agent or principal to their principal. And then we abbreviated those with the word LOADS, L-O-A-D-S. That was loyalty, obedience, accounting, disclosure, and skill, care, and diligence. I'm going to change one of those and ask you to tell me which one's the wrong answer. Speaking of the duty of loyalty, this is a question straight from my real estate exam. The duty of loyalty of a real estate broker owes to a principal includes the following duties. One is to not secretly profit from a transaction involving the principal, to return any secret profit that comes from representing the principal, and to disclose to all parties to the transaction that the broker is somehow related as a sister, brother, or a partner, shareholder, member, or whatever of any business entity involved in the transaction. Okay? Now, for your final exam, if you come to this class, but also the others as well, remember the others legal environment class will be in the room behind me, down that hallway, 1013. I will try to get here early. This class especially, because it's the last class, but because the room is a little bit crowded, if we have some overflow from people who didn't get to take theirs on Tuesday or Wednesday, we'll be pushed for seats. And I always like to start early. So if the room's available, I will get into the rooms on all the exam dates and try to get in here by 11. Your exam's at 12. If you don't get here at 12, that's fine. But I am going to try to get here early, so some people will get in here, take their exams, and by the time 12 gets here, they'll already be gone. This exam is on Thursday.